So next we have Darryl Browne. Darryl is the facilitator for the Law Society of New South Wales Elder Abuse Working Group. Darryl and I just recently got in contact with each other the last few months in regards to the Elder Abuse Conference that's coming up in February. Darryl has a very good background, and it was a very interesting meeting that we had talking about law reform. Of course, as many people in the room would be aware, the Australian Law Reform Commission released their recommendations back in June of this year, and it was probably the largest public inquiry into elder abuse. So there's going to be a lot of focus at our conference on law reform, and Darryl will be touching on some of those issues.
Thank you, Russell, and hello everyone. Thank you for having me today, and Craig and the board and staff and at all. Very important organisation, and it's a great pleasure to be here. I'd like to acknowledge Gadigal of the Eora Nation, pay my respects to their elders past and present, as the traditional custodians of this country. I'm hoping that I can just give you a little overview of the state of play from a legal perspective. So looking at where we're at with reports and perhaps where that may lead in the future, looking at some court decisions, which I'm hoping will be interesting. It's very fascinating for lawyers, of course. I hope for others as well. And looking at some of the actions of the Law Society, just so that I can fill you in, I suppose, on what's happening in the legal arena. You'll know from what Russell just said, and I expect generally, that the Standing Committee of the Legislative Council in New South Wales brought in a report on elder abuse in the middle of 2016. To some extent, the recommendations from that report have been parked because it coincided with the state government having set up an inquiry through the New South Wales Law Reform Commission into guardianship. And so the state government, to some extent, didn't want to preempt the suggestions that will come from the New South Wales Law Reform Commission report. So not a lot has happened in relation to that report at the moment, but that will change in the next 12 months, I confidently predict. You know about the report from the Australian Law Reform Commission in the middle of June 2017. That was released to the public. It was tabled the day before, but released to the public on World Elder Abuse Awareness Day, the 15th of June each year. It's a really important day, and it was great that some extra publicity was given to that occasion this year by the release of that report. The report, coming from a national body, has as its title, Elder Abuse, a National Response. But it expects some buy-in from the states, because much of the jurisdiction in this area around wills, for instance, and powers of attorney, and I'll refer to some of the court decisions about that in a moment, they're state-based matters. That's the state jurisdiction. So the feds just don't have constitutional power to do things in that area, just even if they wanted to. It's a little bit like what Catherine was saying about retirement villages. There is a strict demarcation between the areas of jurisdiction. So what will be the buy-in from the New South Wales Parliament? To some extent that will depend on the report that will come down from the New South Wales Law Reform Commission on guardianship. It's slated that report will be delivered in early 2018. The draft recommendations will be released, I'm told, in about December, so within probably a couple of weeks. And the government has, I think, said to itself it would like to have a response, a considered and thorough response to that, by World Elder Abuse Awareness Day in 2018, which is the middle of June 2018. Which is one of the reasons why I'm confidently telling you that I'm expecting there'll be some important developments in this area within the next 12 months. There already has been developments so far as the courts are concerned. I want to draw your attention to 4 cases in particular in the last 12 months because they, to some extent, explain where the court's going. Parliament, of course, can pass laws. The executive can pass regulations. Courts interpret both of those, but more importantly, they apply the common law. the law that's been developed by earlier courts, often over centuries. To give you a context of that, the earliest decision in relation to testamentary capacity, the mental capacity to make a will, is a decision of 1572. So the court decisions in relation to mental capacity are not a recent development. That's 447 years ago. So we've had lots of courts saying lots of things about important issues in this area. The decision of Smith and Smith, by the way, just before I tell you about these 4 decisions, I should tell you that 3 of them involve a relatively, in fact, long-term existing, but increasing social phenomena in our society, which has got the potential, it seems to me, to stretch the sorts of and exacerbate the sorts of issues that we're going to be talking about. Can anybody tell me what you think that would be?
Inheritance impatience.
Inheritance impatience, yes. I think that to some extent one in particular of these cases involves that, perhaps 2. I was thinking about blended families. They are a much more relevant social phenomena now than they probably ever were in the past. 3 of these decisions involve blended families. Probably the most egregious doesn't. It's just a nuclear family. But anyway, Smith and Smith is a blended family. It was for April. The situation where at the time that Mr. Smith lost mental capacity and his wife, Mrs. Smith, had the ability at that stage to be his attorney under the power of attorney that he'd made, he had an estate of $1.5 million. He had 2 children from an earlier relationship. And in his will, he had said, I'm leaving half of my estate to my wife, second wife, Mrs. Smith, and I'm leaving half of it to my 2 sons. Mrs. Smith decided to buy a residence out at Emu Plains. Emu Plains is about halfway between where we are and where my office is at Lura, out there on just on the other side of Eora Nation, the other side of the Nepean River. And so she bought that property in the name of her daughter and son-in-law, and she used money that she obtained from the sale of Mr. Smith's shares and money from the sale of a unit that was in joint names. After Mr. Smith's death, it was found that the estate had $60,000. It was 1.53 years earlier. What do you think the sons did? Well, the Smith and Smith in this matter are the Smiths who are the 2 sons on the plaintiff's side, and the Smiths who are the Mrs. Smith on the defendant's side. And in fact, there are others because the daughter-in-law and the solicitor and other people got joined into the proceedings as well. The court produced a remedy and basically said that the daughter and son-in-law, even though the property is in their name and registered in their name as real property land, they held it on behalf of the estate because they were knowingly involved in a breach of fiduciary duty by Mrs. Smith when she used the power of attorney Mr. Smith had given her to act in a way which benefited herself and her family. So legal recourse was produced. The other matter that involved a power of attorney was Riley and Riley. That's quite recently. It's only about 3 weeks ago. And that was the nuclear family case. It was a situation where, again, there was a power of attorney, and again, it was given by the man to the wife. Frank Riley had given the power of attorney to his wife, Peg Riley, and she used the power of attorney to transfer the property that was in his name. It was a country property called Baronga, transfer Baronga into her 4 daughters. Now they had, it was a nuclear family as I say, they had a son and 4 daughters. She felt it was fair that the daughters get Baronga because many years earlier in year 2000 she had given the property that had been in her name, Malaya, to the son. So it was fair to change it in that way. So she transferred the property Baronga from Frank Riley's name into the daughter's name for $1. After Frank Riley's death, you can imagine what happened. Riley and Riley. We've got the son on one side of the legal ledger, the plaintiff, and we've got the daughters on the other side of the legal ledger. We've also got Mrs. Peg Riley, the mother who did all this. We've also got the solicitor who's been joined in this as well. Lesson to lawyers, don't get involved in these sorts of matters. Again, the court produced legal recourse. It said that, again, there would be knowingly involvement by the daughters in the breach of the fiduciary duty by the mother in transferring that across. And she thought it was fair, but that doesn't excuse the fact that there wasn't the authority for her to do what she did. And so the court said that was wrong. In Ryan and Dalton, that was a mental capacity case and involved a will, it's a testamentary capacity. In that case, which was handed down just a couple of weeks after the Australian Law Reform Commission report, Justice Kuntz of the Supreme Court of New South Wales referred to the inquiry of the Upper House in New South Wales, the inquiry from the Australian Law Reform Commission, referred to the guidelines that have been issued by the Law Society, and I'll come to those in a moment or three, and then basically said, look, here's some things that good solicitors should be doing. They're probably lessons for all of us, because I actually think whilst they're good things for lawyers to be doing indefinitely, they're probably good things for all advisors to be doing, whether they're solicitors or whether they're financial planners or whether they're accountants or whether they're doctors or somebody else who's involved in giving advice. The client should always be interviewed alone. The judge is a little bit of an absolutist. He always uses always, but I'm not sure that's always advisable. But the client should always be interviewed alone. Really good objective. A solicitor should always consider capacity and the possibility of undue influence, if only to dismiss it in most cases. Always consider it. Most cases you won't need to do more than that. In all cases, instructions should be sought by non-leading questions. Really great objective. Be an investigative, this is what I say when I'm talking to my colleagues, be an investigative journalist. Don't be a cross-examiner. A cross-examiner wants to narrow the answers that can possibly be given, so ask closed questions. But an investigative journalist asks open questions because they're open to whatever information can possibly be conveyed. I'm not sure if always is the right way to describe it, but almost always is probably the best way to describe it. The solicitor should ask the client and their carer or a care manager in the home or facility whether there is any reason to be concerned about capacity. You turn up at the hospital and you say, I'm here to see Mr. or Mrs. Kafoops. Is there any reason why they couldn't do this sort of legal transaction? It's often very interesting to see what the response you get. Often you need to be aware, or I need to be aware as a lawyer, that there's a difference between the legal test for mental capacity and what doctors may use, for instance, assessing where people lie on the spectrum of dementia. They'll use the mini-mental, which is almost completely irrelevant from the legal perspective in determining mental capacity or testamentary capacity. But ask, what's the situation? Are they on medication, for instance? And find out a bit more about that. The fourth case is quite topical because it's got nothing at all to do with elder abuse, but it's a pointer. It's the decision that the High Court handed down just the week before last. It involved a binding financial agreement in a family situation. And again, it had a blended family element. The man involved, Mr. Kennedy, was proposing to marry a new wife. He wanted to protect the inheritance because he was a very wealthy man. He wanted to protect the inheritance to his two children. And basically said, about a week and a half before the wedding, if you want this wedding to proceed, kindly see a solicitor and sign the binding financial agreement. Now, apart from the fact that it was so pressured, when all the guests had been asked already, the wedding had been booked, all the arrangements had been made, people had come from overseas where the bride had previously lived to travel to Australia. The solicitor who advised Ms. Thorne about it basically said, this is the worst binding financial agreement I've ever seen. The judge at first instance in the family court set it aside, it was overturned in the full court of the family court, but the High Court said no. It just doesn't withstand the requirements of a person entering into this knowingly, voluntarily, and understanding it fully. So it said 5-1 that it was induced by undue influence, and 7-zip that it involved unconscionable behaviour on behalf of Mr. Kennedy. In fact, Mr. Kennedy had died, and the litigation was effectively conducted by his children. So again, a blended family position. Now, I'm being told that I've run over time, so I will just move on to two things very quickly. The first is in relation to the Law Society. The Law Society has been active in this area for some time, but has become more active more recently. Firstly, in 2016, a publication which had been put out to assist solicitors when they were seeing clients and assessing mental capacity was revised. And then there was a whole series of articles in the Law Society Journal, the journal for lawyers or solicitors, and there are a whole lot of CPD programs run by the Law Society to better educate the profession around the sorts of issues we've been talking about. It established just last Thursday, the formal resolution was made, the announcement had been made back in June, but just established last Thursday the Elder Abuse Working Group, and I've been asked to facilitate that working group. So we've brought lots of solicitors together and brought together their expertise from a whole range of different disciplines in the law, and from expertise from academia and other areas. Hopefully that's producing some response. The Office of the Legal Services Commission, which is the independent body that co-regulates the behaviour of lawyers with the Law Society itself, has got some statistics about the number of complaints that come before it which are based on particular problems. And there had been an increasing trend about complaints that were based on solicitors wrongly assessing mental capacity. In the last 12 months, 2016, 2017, that dropped. So the first time that trend turned around. Now that's quantitative. They don't know the reason, qualitative, but the Commissioner, John McKenzie, basically says he thinks it's because of some of the work the Law Society has done is assisting in this area. So that's very pleasing. We all know, as Alan Madden was saying, about the fact it's an ageing population. The statistic that rings true most for me in that regard is that at the present time about 15% of our population is over the age of 65. By the time we get to 2050, that's projected to be 23%, about 50% increase in the next 30 odd years. So that's why there will be opportunities, it seems to me, unfortunate though that is, for elder abuse and elder financial abuse particularly, which is what lawyers in my area see most. There's an incentive, and the incentive is going to grow faster than that growth in the ageing population. At the moment, 25% of Australians' wealth is owned by those people aged 65 years or over. 25% is owned by that 15%. By 2050, it's projected that the wealth will be owned by that cohort will own 45%. So whilst the number of aged over 65 will increase by 50% in the next 30 odd years, their wealth of percentage of Australia's wealth will increase by 80%. Now it seems to me that that's got this potential problem. Whatever we think the issue now is around elder abuse, and specifically elder financial abuse, that's going to get worse. So the ambition that I have and the Law Society has, and I think we all need to embrace, is that if we can get proper legal engagement, we can turn that around. We can have it so that it doesn't produce what would otherwise seem to be an inevitable response to that change in demographics and in ownership of wealth. Thank you for your time and good work.